All right.
All rise. Reminder, while I just set up, each contestant will have 20 minutes to speak, at which point, after all 4 contestants have gone, we'll allow the appellants 5 minutes to prepare a rebuttal, for which you'll have 3 minutes speaking time for the rebuttal.
Good evening, your ladyships. My name is Tanvi Nanda. I, along with my fellow counsel, Ms. Charlotte Evans, will be representing the appellant Sterling in this case. My learned friends, Mr. Riley Gibbons and Ms. Charlotte Green, will be representing the respondent, Longfield NHS Trust. Would your ladyships care for a summary of the facts?
Yes, please. Just a short summary.
Ms. June Sterling was admitted to the labor ward of Longfield NHS Trust while 40 weeks pregnant and in the early stages of labor. Due to a busy and understaffed environment, Ms. Sterling was inadequately attended to for a prolonged period of time. It was later discovered that the device monitoring the heartbeat of the child was disconnected and the baby was in distress. Ms. Sterling was then rushed for an emergency cesarean. However, the severe delay resulted in her baby sustaining severe brain damage. The baby was then transferred to another hospital while Ms. Sterling was unconscious, and the news of her child's condition was only revealed to her the following evening as she was taken to see him. Ms. Sterling suffered post-traumatic stress disorder as a result of the traumatic events surrounding her child's birth and the subsequent discovery of his condition. This case encompasses the 2 grounds of appeal, asserting the determination of Ms. Sterling's status as a primary victim, focusing on the application of the White test and the interpretation of sudden shocking event. If it pleases your ladyships, may I begin with the first submission?
Yes, please.
It is submitted that the criteria of the White test is restrictive and alternative elements must be considered. If I can direct your ladyship's attention to the case White and others and the Chief Constable of South Yorkshire Police in 1999, the 2nd volume of appeal cases, starting on page 455 of the case. This is located on page 9 of the appellant's bundle, and the highlighted section is on page 458 of the case. Would your ladyships care for a summary of the facts?
Could you just give me the page reference again, please?
Page 9 of the appellant's bundle and page 458 of the case.
Yes. Okay.
Would your ladyship's care for a summary of the facts?
Yes, please.
The White case involved police officers who were involved in the aftermath of the Hillsborough disaster in 1989, where 96 individuals were tragically killed during a football match. The police officers, although deeply affected by the harrowing scenes that they witnessed and subsequent trauma, were held not to be primary victims. The court ruled they themselves were not in any physical danger, nor reasonably believed themselves to be so, and thus did not meet the criteria for primary victims in claims of psychiatric harm. The White test has long been relied upon when determining primary victim status. It sets a standard whereby individuals must be objectively exposed to danger or reasonably believe themselves to be so to qualify as victims. While the White test served as significant legal precedent, its applicability has come under scrutiny in cases such as Ms. Sterling's. This test focuses on the immediate danger, fails to account for the complex and evolving nature of traumatic experiences. The highlighted section in the case sets out the traditional distinction between primary and secondary victims based on physical injury. However, it fails to fully capture the complexities of traumatic experiences, particularly in cases involving psychological harm. In Ms. Sterling's case, while the negligence of the hospital did not directly cause physical harm to her, it undoubtedly led to severe psychological distress and trauma. By rigidly adhering to a narrow criteria set by the White test, there's a risk of overlooking the reality that individuals like Ms. Sterling can experience profound harm despite not sustaining any physical injuries. Instead, it would be more productive to adopt a more nuanced approach that considers the full spectrum of harm experienced by individuals directly involved in traumatic events, including psychological distress and trauma. If I can direct your ladyship's attention to the case of AB and Leeds on page 112 of the appellant's bundle and page 555 of the case.
Could I ask you to just slow down a little bit? You're giving us a lot of information and you'd be really using time to absorb what you're saying, think about what you're saying. What page number was it again?
Page 112 of the appellant's bundle and page 555 of the case. The ladyship's care for summary comments.
Could you just give me a précis of the ratio in this case?
Certainly. In this case, this case centered on whether the hospital's actions constituted breach of duty and whether the claimants could be considered primary victims of the hospital's negligence. And in this case, they held that as there was no primary victim as all the children were dead in that case, the claimants were held as primary victims. In this case, the foreseeability test was brought up, and it offers an alternative approach to determining primary victim status. Rather than solely considering the proximity to danger, this test evaluates the psychiatric harm, whether the psychiatric harm suffered was reasonably foreseeable. This highlighted section from the Leeds case emphasizes the importance of recognizing the foreseeability of psychiatric harm in traumatic situations, such as discovering medical negligence. It acknowledges that individuals may experience psychiatric problems as a result of traumatic events, even if there are no immediate physical injuries. The foreseeability of psychiatric harm in Ms. Sterling's case can be inferred from the inherently traumatic nature of emergency medical procedures, in this case, the emergency cesarean. Such procedures carry inherent risks and can induce significant emotional distress in patients, especially expectant mothers like Ms. Sterling. Furthermore, expert medical testimony can support the contention that psychiatric harm was reasonably foreseeable given the circumstances of Ms. Sterling's childbirth. By emphasizing the foreseeability of psychiatric harm, the different considerations taken in the AB and Leeds case challenge the strict definitions of primary and secondary victimhood set forth in the White case. It acknowledges the need for understanding the complexities of trauma and our evolving understanding of psychiatric harm, highlighting the need for a much more flexible and nuanced approach when assessing harm. In Ms. Sterling's case, the foreseeability element offers a more suitable framework for evaluating her primary victim status, as it acknowledges the foreseeable risk of harm associated with negligent care during childbirth.
Question about that. We're talking about foreseeability and proximity. If you're right on this, would it not be more foreseeable that the claimant was traumatized or potentially traumatized by the cesarean section, and that to go a step further and say that she was potentially traumatized by her baby being brain damaged? Is that not stretching it too far in terms of foreseeability?
As I further discuss in the next following two submissions, the relationship between the claimant and her child are also important factors to consider when we're considering the foreseeability of the situation. The White test limitations when addressing complex traumatic experiences, such as those endured by Ms. Sterling, warrant the adoption of the foreseeability test as an alternative approach to assessing primary victim status. It's imperative to consider the merits of foreseeability and adapt our legal principles to reflect modern understandings of trauma and negligence. If it pleases your ladyships, may I move on to the second submission? It is submitted that Ms. Sterling's recognition as a primary victim is grounded in the legal principle that acknowledges the impact of prenatal negligence on maternal well-being. If I can direct your ladyship's attention to the case of YAH and Medway on page 136 of the appellant's bundle and page 1413 of the case. Your ladyship's there for some facts.
Very, very briefly. Very easy.
In the Medway case, a baby was born with cerebral palsy as a consequence of oxygen deprivation due to negligence during the delivery. The court examined whether the mother could be considered a primary victim of the medical negligence and whether she was entitled to compensation for psychiatric harm resulting from witnessing the harm to her child. This case raised the question about the legal status of the mother as a primary victim in the cases of medical negligence during childbirth. This highlighted section from the Medway case emphasizes the legal principle that until birth, a baby is regarded as part of its mother, and there exists a single legal person. This principle reflects the long-standing legal and philosophical concept of fetal personhood, recognizing the close legal and biological relationship between the mother and child. As such, any injury suffered by the mother as a result of negligence before the birth of the child is considered personal injury to the mother herself. This acknowledgement highlights the interconnectedness of maternal and fetal well-being and emphasizes the duty of care owed to both entities during pregnancy and childbirth. Ms. Sterling was admitted to the hospital and was prepared to entrust her health and her baby's health to the professionals. Due to the hospital's negligence, the complications of the birth were increased by the delay, resulting in brain damage to the child. In the Medway case, the court held that there was no primary victim, as the fetus and the mother were considered one entity before birth. In order for there to be a secondary victim, there must first be a primary victim. Recognizing Ms. Sterling as a primary victim would acknowledge that she suffered injury as a consequence of the negligence that occurred before the childbirth. Moreover, recognizing Ms. Sterling as a primary victim acknowledges her role as a caregiver and protector of her unborn child, and affirming her right to seek redress for any harm that inflicted upon her during childbirth. The legal recognition of fetal-maternal interdependence addresses the absence of a distinct primary victim in cases where the harm physically affects the unborn child. Ms. Sterling and her unborn child were legally considered one entity before birth. This recognition of Ms. Sterling as a primary victim under the principle of fetal personhood has direct implications for addressing the trauma and negligence that she endured during childbirth. Ms. Sterling's status as a primary victim validates the severity of harm that she suffered as a result of the hospital's negligence when monitoring her condition. This recognition serves to underscore the connectedness between maternal and fetal well-being, emphasizing the duty of care owed to Ms. Sterling as a mother and a patient. Moreover, it reinforces the need for comprehensive support and redress for Ms. Sterling's psychological trauma, recognizing the lasting impact of medical negligence on her mental and emotional health, which does by embracing a holistic understanding of Ms. Sterling's situation and her experiences, rather than adhering to a stringent criteria. It recognizes and assists her in navigating the aftermaths of a very traumatic childbirth. And this recognition would not only address Ms. Sterling's suffering, but set a precedent for addressing similar cases of negligence and trauma around childbirth, with a sense of empathy and accountability within the legal system. If it pleases your ladyships, may I move on to the third submission?
Can I just ask you a question? What do you say are the parameters around the duty of care that's owed by the medics to the appellant?
When we're discussing the duty of care, my junior counsel will further discuss that as well in her submissions. But as a patient and as a mother, since the concept of fetal personhood acknowledges both Ms. Sterling and her child as the sole victim of the negligence until the child was born, the duty of care was over with them. It is submitted that Ms. Sterling's direct involvement throughout the traumatic events of childbirth strengthened her status as a primary victim. If I can direct your ladyship's attention to the case of R.E. and Calderdale on page 174 of the appellant's bundle and page 220 of the case. Would your ladyship say also some of the facts?
Yes, please.
In the Calderdale case, the claimant, a mother, underwent traumatic childbirth where her baby suffered brain damage through delayed delivery. This negligence occurred when the baby's head had crowned, but the body remained in the birth canal, causing prolonged distress. The court considered the directness and proximity of the harm to the mother, emphasizing that she was directly impacted by witnessing the harm to her child during childbirth. This case raises questions about the legal status of the mother as the primary victim, highlighting the significance of directness and proximity when discussing primary victimhood in cases of medical negligence surrounding childbirth. Proximity and direct impact play crucial roles when determining primary victim status, particularly in cases where the claimant is directly involved in the traumatic events. Ms. Sterling's experience during childbirth directly impacted her mental and emotional well-being.
What weight do you say should be attached to the fact that she was unconscious throughout the delivery?
Regardless of whether she was unconscious or not, the concept of post-traumatic stress disorder is constantly evolving when we're discussing how the implications can affect an individual. Even if Ms. Sterling woke up unconscious and not knowing where she is, she can still suffer post-traumatic stress disorder. She doesn't need to be awake during the emergency cesarean to suffer that harm. The highlighted section from the Calderdale case discusses the intimate and immediate relationship between the mother and child, which mirror that of Ms. Sterling and her baby. It emphasizes the nature of the child's condition at birth, with no warning or preparation for the life-threatening situation that unfolded. This highlighted section emphasizes the profound impact of traumatic events on Ms. Sterling as a mother, reinforcing the argument for her recognition as a primary victim of the negligence that occurred during childbirth. Furthermore, Ms. Sterling was not just a passive bystander, but she was directly involved throughout the traumatic events, experiencing the emotional and physical toll firsthand. A bystander is typically defined as someone who's present at an event, but is not directly involved. In Ms. Sterling's case, she cannot be considered a bystander as she was directly involved in every single element during her child's birth.
But she was unconscious, wasn't she?
But she was the one who underwent the emergency cesarean.
But she had no awareness of what was happening because she was unconscious.
But that's why we need to adapt our legal situation, our legal principles to reflect our modern understandings of trauma.
Ms. Nanda, can you help with how long? Could it maybe that I miss this in the agreed facts? But how long was it that she was unconscious for?
They don't discuss the length of the emergency cesarean. They discuss how long she was unattended for, inadequately attended for.
Do you know if she was unconscious throughout the entire delivery?
She was unconscious throughout the entire delivery, yes. But as I said, unconsciousness doesn't determine the fact that she will suffer any post-traumatic stress syndrome. Upon waking up and discovering that her baby had been shifted to a different hospital and she had underwent an emergency cesarean are also factors that we need to consider as it could be traumatic.
So where's the legal principle that underlines what you say?
Okay, yes, just forget. As Ms. Sterling was the one who underwent the emergency surgery herself, and she specifically an emergency cesarean section directly involving her in the medical procedure, her subsequent discovery of her baby's severe brain damage further compounded her distress and trauma. Ms. Sterling's active involvement in the medical intervention and the subsequent emotional response precludes her from being classified as bystander in this context. This further strengthens her argument for her recognition as a primary victim, as she was not merely an observer, but a central participant in the events unfolding.
That she was unconscious of.
Yes, that she was unconscious. She was the one who underwent the medical procedure. Ms. Sterling's involvement in not being a bystander provides valuable context for evaluating the proximity and direct impact that negligence can have on psychological harm. Ms. Sterling, as a primary victim, highlights the imperative of honoring individual experiences and perspectives in cases of medical negligence. And by embracing a comprehensive understanding of Ms. Sterling's circumstances and the contextual elements of the case, the court can ensure equitable acknowledgement and support for Ms. Sterling as she navigates the aftermath of a very traumatic childbirth. In conclusion, there are 3 reasons to consider Ms. Sterling as the primary victim. Firstly, it's evident that the respondent should have foreseen the significant psychiatric harm Ms. Sterling would endure due to the necessity of an emergency cesarean section and the severe distress that the baby and the mother underwent. Secondly, the unique.
Could you just repeat the first one again, slow down a little bit, because we really do need to listen very carefully to what we say, this is important. So the first one again, please.
Firstly, it's evident that the respondent should have foreseen the significant psychiatric harm Ms. Sterling would endure due to the necessity of an emergency cesarean and the severe distress that the baby and the mother underwent. Secondly, the unique legal status of Ms. Sterling and her unborn child as a single legal entity during the period of negligence identify them both as the sole victim of the negligence by the hospital. And finally, Ms. Sterling's intimate involvement and direct impact in the events surrounding the traumatic birth unequivocally refute any notion of her being a bystander. The case of Ms. Sterling presents a pivotal opportunity for the judiciary to refine its understanding of primary victimhood in cases of medical negligence surrounding childbirth. As this case unfolds before the esteemed Supreme Court, the precedent set will not only shape Ms. Sterling's path to justice, but affirm fundamental principles of empathy, fairness, and accountability within our legal system. With these considerations in mind, we urge the court to uphold the integrity of our legal framework by granting Ms. Sterling the primary victim status. Unless I can aid the court any further, this concludes the submissions on behalf of the legal appellant.
Good evening, your ladyships. My name is Sade Evans, and I will be arguing on the second ground of appeal. This being that Lord Justice Nixon was incorrect in his application of the requirements and of the elements of duties set out by Alcock and others and Chief Constable of the South Yorkshire Police to the factual situation of Ms. Sterling. If it pleases your ladyships, I'll begin my first submission. In the Court of Appeal, one of the factors Lord Justice Smithson used to decide that no duty was owed to Ms. Sterling is that she did not witness a sudden shocking event. The definition of what is deemed shocking was defined in the case of Alcock and others and Chief Constable of the South Yorkshire Police, found on page 308 of the appellant. Would your ladyships care for a summary of?
I think we're all familiar with this case, thank you.
If I could direct your attention to paragraph F on page 401 of the case, found on page 399 of the appellant bundle. Lord Ackner states that shock in the context of this cause of action involves the sudden appreciation by sight or sound of a horrifying event which violently aggravated the mind. This is the first reason this requirement is misapplied, is that it is in the terms of secondary victims who are not directly involved in the accident. As my learned friend Ms. Nanda discussed, Ms. Sterling is a primary victim and should be held by those requirements and restrictions. Since she is a primary victim, the sudden shocking event would not be something that she would witness, but rather something she was either directly involved in or happened to them. The other and more pressing reason that the application of this requirement was incorrect is the specific requirement of the event being sudden and shocking. This has since been overruled by the Supreme Court. If I could direct your attention to Paul and Another and Royal Wolverhampton NHS Trust, found on page 176 of the appellate bundle.
Could you give me that reference again, please?
Paul and Another and Royal Wolverhampton NHS Trust, which is found on page 176 of the appellate bundle. Would your ladyships care for summary of the facts?
I think we're familiar with this one as well. If
If I could direct your attention to paragraphs H and A found on pages 439 to 440 of the case, which is found on page 198 and 199 of the appellate.
1 seconds, so many numbers committee, please.
198 and 199 of the appellate bundle.
Could I also ask you to slow down? What you're saying is really important, and we really want to take on board everything that you're saying. Just slow down, I know you're nervous, but it makes a huge difference to us, if you would please.
Paragraph eight. Thank you. Thank you.
Paragraph H.
It begins on page 198 on paragraph H. The court here states that this test is not one of the requirements established by Alcock and confirmed in Frost. And in grafting onto those requirements, additional requirements of needing to prove that the claimant's injury was caused by the mechanism of a sudden shock to the nervous system and was a sufficiently horrifying event, the law has, in our opinion, taken an unfortunate wrong turn, which these appeals would enable us to correct. Although Alcock defined what shock is in terms of this tort, it is not listed as the necessary elements and has been incorrectly read into those elements. This illustrates how the court has recognized an overly restrictive manner of having this requirement and has done its duty to correct this mistake. It is clear that this requirement is no longer good law and therefore should not have been relied on by Lord Justice Smithson in his ratio decidendi when deciding Ms. Sterling's case. The correction made by the Supreme Court is binding on Lord Justice Smithson, and therefore this aspect of his reasoning should be dismissed. It would be unfair and unjust to hold Ms. Smithson to a restriction that was done away with by the common law. It was and would be unnecessary to interpret this restriction as a requirement of Alcock and should not be taken into consideration by this court, since it has been established as an unfortunate wrong turn of the law. If it pleases your ladyships, I'll begin my second submission. Thank you. In order to claim damages for psychiatric harm, the thing that causes the illness must be one event. This is because in order to make a claim, there must be sufficient proximity between the claimant and the time or the immediate aftermath of the event. It should be noted that this requirement is only relevant in terms of secondary victim. However, for argument's sake, I will be showing that nonetheless, Ms. Sterling fulfills this requirement. In Ms. Sterling's case, the event lasted between 24 to 48 hours and was one single event. If I may direct your attention to the case of Walters and North Glamorgan NHS Trust found on page 244 of the Bible.
Can you help with the citation of that case, please?
Yes. It was in 2002 of the Court of Appeal.
In which jurisdiction?
England and Wales.
Can you remind me of the page number, please?
Of the case or on the bundle?
On the bundle, please.
It's found on page 244.
Thank you.
Would your ladyships care for summary of facts?
No, thank you.
If I may direct your attention to paragraph 34 of the judgment, which would be found on page 259 of the appellant bundle. Lord Justice Ward stated, "In my judgment, the law as presently formulated does not permit a realistic view being taken from case to case of what constitutes the necessary event. Our task is not to construe the word as if it had appeared in the legislation, but rather gather a sense of the word in order to inform the principle to be drawn from various authorities. It is a seamless tale with an obvious beginning and equally obvious end. It was played out over a period of 36 hours, which for her both at the time and as subsequently recollected, an undoubtedly one drawn out experience. One significant similarity between these
Can I
cases."
just pause you there? Within this paragraph, it does actually say very clearly that it's a matter of judgment from case to case, depending on the facts and circumstances of each case. So why do you say that this is relevant to the case in hand?
The facts
That
of
how it's different?
There is a difference, yes. However, the facts of the case of Walters and the facts of this case with Ms. Sterling is very similar, especially within the time frame of what has happened.
But Miss, I can't remember the name of the claimant was unconscious, wasn't she? For a significant period of time. Does that not make a difference to your point that you're making here?
It does not, as my learned friend has stated. It also should be noted that it would add on to her trauma, seeing as for most cesarean operations, person would be conscious. And so the fact that she had to be put unconscious would add on to her trauma that she suffered.
I'm struggling to understand how that would add to her trauma if she was unconscious.
She should not have had to be unconscious in the first place, if the hospital was not negligent in their care.
Was on the facts of this authority you rely on, was there any period that that victim was unconscious?
Not to my knowledge. One significant similarity between these cases is the fact that Ms. Sterling was present for the negligent act and the immediate aftermath of the negligent act during the viewing of her baby. Another is that the time frame for this event was similar, seeing as Walters was lasting 36 hours and our case here is sometime between 24 to 48 hours. Within that same paragraph, Lord Justice Ward uses the metaphor to illustrate what can be defined as an event. He says an item in a sports program or the program as a whole. This would define an event as something that can happen in either a moment or over a period of time and can only and should only be seen subjectively. Applying the principles set out in Walters and North Glamorgan NHS Trust, Ms. Sterling's situation was a seamless tale with an obvious beginning and an equally obvious end. From the moment the negligent act of the hospital happened to the discovery of her son's condition, no other events occurred or separation in time from the beginning to the end. For this reason, it was wrong of Lord Justice Smithson to deem what happened as multiple events, when in reality it was one event that occurred during many consecutive hours. There was no separation between the psychiatric injury causing event and the original negligence, since one could not have happened without the other. It should also be noted that there was no separation since Ms. Sterling was informed of her son's condition upon the viewing of her son after her transfer, as it states in the case facts that she was not informed until she was taken to see her son. It is for those reasons that Ms. Sterling's situation should be viewed as one singular event that occurred within an extended time frame and therefore sufficiently fulfills the proximity element required to establish her duty. If it pleases your ladyships, I'll begin my final submission. Thank you. In the Court of Appeal, Lord Justice Smithson used the elements set out in Alcock to determine if Ms. Sterling was owed a duty of care not to cause her psychiatric harm. As I discussed in my first submission, the requirement of an event being sudden and shocking is not good law and should never have been used in the first place as a restriction against Ms. Sterling. In terms of the other elements, if I may direct your attention to the case of Alcock found on page 308 of the bundle. If I may direct your attention to paragraphs A and B found on page 309 of the bundle. The elements of the duty are as follows. In order to establish a claim in respect of psychiatric illness resulting from shock, it was necessary to show not only that such injury was reasonably foreseeable, but also the relationship between the plaintiff and the defendant was sufficiently proximate. That the class of persons to whom a duty of care was owed as being sufficiently proximate was not limited by reference to particular relationships such as husband and wife or parent and child, but was based on ties of love and affection, the closeness of which would need to be proved in each case. That remoter relationships would require careful scrutiny, and that a plaintiff also had to show proximity in time and space to the accident or its immediate aftermath. When these elements are applied to the factual situation of Ms. Sterling, it is clear that all the elements are present and that she was owed a duty by the hospital. First, she had a sufficient proximate relationship of close ties in love and affection, as her and her son would fall into the presumed category of parent and child. The court has established that although these kinds of relationships are not the limit, they are, however, the threshold for the strength of a bond of the relationship that has to be present in order to be deemed sufficiently proximate. The next element is that the claimant would have to show a proximity to the event or its immediate aftermath. As I discussed in my previous submission, Ms. Sterling has been involved in the entire event, which began with the initial negligent act and ended with her seeing the immediate aftermath of said act. She therefore has fulfilled the necessary element of proximity. The final element that is necessary to show that a duty was owed is if such an injury was reasonably foreseeable. As my learned friend, Ms. Nanda, discussed, based on the negligence and the event that occurred, it would be reasonably foreseeable that Ms. Sterling would become psychiatrically injured because of it. Not only did she have to go through an emergency procedure, which led to her consciousness, but had to see her newborn baby with severe brain damage. The hospital should have foreseen that Ms. Sterling would suffer from a psychiatric illness as a result of their negligent act towards her son. Therefore, Ms. Sterling's situation would fulfill all the necessary elements set out in Alcock and should be owed a duty of care. However, these are the requirements to establish a duty for a secondary victim. And as my learned friend, Ms. Nanda, stated, Ms. Sterling should be held as a primary victim and therefore different tests of establishing a duty. I could direct your attention to Page and Smith found on page 264. Would your ladies care for a summary of the facts?
No, thank you.
If I could direct your attention to paragraph F found on page 296 of the bundle. The House of Lords established that since the defendant was admittedly under a duty of care not to cause the plaintiff foreseeable physical injury, it was unnecessary to ask whether he was under a separate duty of care not to cause foreseeable psychiatric injury. This principle establishes that so long as a physical harm is foreseeable, psychiatric harm should be as well. Applying this to Ms. Sterling's case, the physical harm was foreseeable as the hospital admitted negligence with respect to the severe injuries. Therefore, Ms.
Can you
Sterling,
clarify, when you talk about severe injuries, are you talking about severe injuries arising from the cesarean or the injuries to the child?
both, but primarily the injuries of the child. And since the negligent act happened while he was still in the womb, they were considered one legal entity, and therefore she would be the primary victim.
Thank you, sorry, I interrupted you mid-floor, carry on.
Nice. Therefore, Ms. Sterling's psychiatric injuries were also reasonably foreseeable, and she should be owed a duty of care. To summarize, Lord Justice Smithson was wrong in his application of the elements set out in Alcock, as Ms. Sterling fulfills each one. However, this should not have been the test used in the first place, since it applies to secondary victims and Ms. Sterling is a primary victim. The elements that should have been applied are those set out in Page and Smith, which her situation meets. In conclusion, Ms. Nanda and I request that your ladyships overturn the decision of the Court of Appeal and find for the appellant, Ms. Sterling. This is on the ground that Ms. Sterling was wrongfully categorized as a secondary victim when in reality she was a primary victim. This is because foreseeability should have been considered. Fetal personhood would apply in this situation, and Ms. Sterling was directly involved in the traumatic event. This is also on the ground that the elements of duty were misapplied and misinterpreted by Lord Justice Smithson. The reasons being the requirement of a sudden shocking event was unnecessary and too restrictive. The situation equated one long event rather than multiple. And the elements set out in Alcock were misapplied in light of the particular factual situation at hand. Unless I can aid the court further, this would conclude the submissions on behalf of the jurors of Appellant.
Just one question, if I may, please. Just on the last point that you raised, in the case of Page and Smith, there's an extract that you referred to where it talks about the defendant being under a duty of care not to cause the plaintiff foreseeable physical injury. And it's therefore unnecessary to ask whether there's a separate duty not to cause foreseeable psychiatric injury. Is it the case then that if we rule on the first ground of appeal that Ms. Sterling is a secondary victim rather than a primary victim, does that test fall away in that if there was no physical harm to her, there was no duty of care not to cause psychiatric harm?
Respectfully, no, or the test does fall away. However, in my submission, I did state that if you were to categorize her as a secondary victim, she would fit all the elements required set out for a secondary victim to claim for psychiatric harm.
Thank you.
So therefore, no matter what test that she is categorized as, she is owed a duty of care for her psychiatric.
Thank you.
Unless there's anything else. Thank you.
Ms. Given.
Good evening, your ladyships. I, Riley Given, appear along with my learned friend, Miss Charlotte Green, appear on behalf of the respondent, Longfield NHS Trust. It is submitted on behalf of the respondent that this court should uphold the decisions made by Lord Justice Smithson in the Court of Appeal, and find that the test in the case of White and others was applied correctly to find that Ms. Sterling was not a primary victim, and that no duty was owed to Ms. Sterling as a secondary victim due to a lack of a sudden shocking event, a requirement outlined by the Alcock and others case. Focusing on the first ground of appeal, it is submitted that Ms. Sterling does not qualify as a primary victim, according to the case of White and others. It is further submitted that this was also the correct test to apply, outlining all of the requirements for either a participant or a bystander within the zone of danger. If it pleases your ladyships, I will now begin my first submission. It is submitted that White and others applies a reasonable, objective test, which can be applied to most, if not all, circumstances which deal with psychiatric harm. If I may direct your ladyship's attention to the case of White and others and the Chief Constable of South Yorkshire Police and others, found starting on page 7 of the Respondent's bundle, page 455 of the law report.
Sorry, Mr. Gibbon, that page again.
First,
7. Mr. Gibbon, don't want to be a stickler for the rules, but what's the citation for that case?
the citation is the Second Appeals Court Law Report of 1999, number 400, starting from page 455.
Right, well, thank you.
The case of White and others assesses whether a claimant can be found as a primary victim using a simple two-pronged test. Firstly, was the claimant in any danger? And secondly, could they have reasonably believed themselves to be in this zone of danger as outlined by White and others?
Where are we looking for in the authority for that?
My apologies. This would be on, my apologies, on page 458 of the law report, page 10 of the bundle, paragraph H. It is submitted that while the original language in the judgment of White and others contains language specific to rescuers, it is submitted that this is broadened within the same judgment, specifically to the highlighted section of paragraph H, as I have previously directed your ladyship's attention to. It is submitted that Ms. Sterling was never in any physical danger, nor could she have reasonably believed herself to be in this physical danger. As was found in the facts of the case at hand, it is submitted that Ms. Sterling was unconscious throughout the entire procedure of the emergency cesarean, and as such, could not reasonably believe herself to be in a zone of danger, as she would be under the care of medical professionals and unconscious throughout the delivery.
Does the appellant not have a good point though, that normally cesareans are carried out under local anaesthetic by epidural, and that the fact that that the claimant, the appellant, I beg your pardon, knew that she was going to be given a general anaesthetic, would that not have does that not fly in the face of the point that you're making?
It is submitted that while that may be an original perception, it is submitted, however, that as she was unconscious, she could not have perceived herself to be have any visuals throughout the entire delivery or procedure, and as a result, could not have been reasonably expected to have believed herself on a balance of probabilities that she would have been in any danger.
But doesn't the fact that she knew she was going to be unconscious, and the fact that she may well have anticipated what was going to happen through the procedure, does that not feed into the appellant's argument about the injury she suffered?
Respectfully, your ladyship, it is submitted that general anesthetic being applied and to render an individual unconscious while in the care of medical professionals, it would not be reasonably expected for an individual to believe himself that anytime they are placed under a general anesthetic while under watch by medical professionals for the delivery of their child, that they would believe themselves to be in a zone of danger, that they themselves would be at risk of harm.
I think This is a lady who knew that there was something wrong at the time because prior to going into surgery, because the medical professionals were concerned about the monitor not working properly. She rushed into surgery. She's expecting a cesarean by epidural. She's told she's going to have a general anaesthetic. Professionals are very worried. Does that not have an impact on what you are saying about her not being a primary victim?
Unfortunately, issue. It is submitted that I unfortunately not limited within the facts of the case as to whether or not the medical professionals conveyed any sense of worry or urgency. Further, it would be submitted that the general anesthetic that she would have been placed under, my apologies, it was submitted that at no time after she had woken up was she concerned for her safety. According to the facts of the case, it was not stated anywhere until she was later informed of her son's condition. Further, it is submitted that if the damage sustained to Ms. Sterling's child, according to YAH, as submitted previously by my learned friend, Ms. Nanda, it is submitted that the case of YAH, along with the other cases submitted by my learned friend, are high court cases. As a result, while they are persuasive, they are not binding upon this court. Further, it is submitted for the bench's consideration and determination to find that the high courts had erred in their decision of YAH. It is submitted that a baby, mere hours from being born, would not be reliant on their mother during the delivery, as she was unconscious and in the care of medical professionals during the emergency cesarean. As a result, the mother, whom was not suffering from these same injuries as the child, should not be considered to have suffered the same danger and harm resulting that had been inflicted upon the child. It is submitted that Longfield NHS Trust, while they have admitted to negligence on the part of Ms. Sterling's son, Liam, it is submitted that at no point has Longfield NHS Trust admitted negligence on the part of Ms. Sterling's emergency cesarean, and that it is further stated that it is not within the fact that there was any long-lasting injury sustained to Ms. Sterling as a result of the cesarean. As a result, it is submitted that finding that the damage inflicted upon Liam as also being attributed to and inflicted upon Ms. Sterling would potentially open the floodgates if this was to be decided at the Supreme Court level, where multiple close parties can claim for damages when only one party had actually suffered any harm.
So when you talk about suffering harm, are you talking purely about physical harm? Presumably you accept that post-traumatic stress disorder is a form of harm.
Absolutely, Your Ladyship. However, it is submitted that while the hospital did owe a duty of care to the physical and psychiatric well-being of the son, that, as will be discussed later by my learned friend, Ms. Green, as there was no duty of care owed to Ms. Sterling's psychiatric injury sustained of PTSD. In the alternative to finding that the courts had erred in the application of law in YAH, it is submitted that the facts of this case are distinguished from the previous cases, such as YAH. It is submitted that, on behalf of the fact that there was no direct involvement on the part of Ms. Sterling, as she was unconscious throughout the entire procedure. As a result, she was not present to be able to witness the delivery and any harm or complications caused during the delivery, as was outlined by the previous cases of my learned friend, Ms. Nanda. If it pleases Your Ladyships, I will now move on to my second submission.
Please.
It is submitted that it is unreasonable to find that the harm suffered by Ms. Sterling was within the realm of foreseeability, reasonable foreseeability, my apologies, by the hospital. If I may direct Your Ladyship's attention to the case of Page and Smith, found on page 64 of the Respondent's bundle.
Again, the citation, Mr. Given.
Of course. Page and Smith reported in the first appeals court law report of 1996, starting from page 155. It is submitted that while the hospital has admitted negligence on the part of the harm suffered to the son, with the harm inflicted upon the son being reasonably foreseeable due to the negligent care received by medical professionals, there is no admittance of any negligence or duty of care owed to Ms. Sterling, and further it is submitted that the harm suffered by Ms. Sterling would not be reasonably foreseeable. If I may direct your ladyship's attention to an excerpt from Page and Smith, found at page 71 of the bundle, the highlighted section of paragraph C.
71.
Yes.
Why am I anything on that? Oh, okay.
It reads, and I quote, "The need to establish that the damage which occurred was foreseeable remains, and the tests to determine whether foreseeability is established are the same in both categories of cases," to which they outline the Alcott case, of which in far greater detail by my learned friend Ms. Green in his submissions concerning Ms. June as a secondary victim. In the alternative, it is submitted that even if the courts do find that the harm inflicted to Ms. Sterling was reasonably foreseeable, it is submitted that foreseeability is not the only criteria that must be met in order to satisfy a claim for psychiatric harm. This further strengthens the fact that the case of White and others was the correct test to apply in this application. For this, if I may direct your ladyship's attention to an excerpt from the case of White and others, found on page 23 of the bundle, page 471 of the law report, paragraph G. Towards the bottom of the page. It is stated, and I quote, "It is right that I should conclude this section of this opinion with the observation that foreseeability of psychiatric injury, while constituting a unifying principle of this branch of the law, cannot be regarded as providing a universal touchstone of liability." The judgment further quotes Justice Windire, I apologize if I pronounced the name incorrectly, at the bottom of page 23, continuing on to the top of page 24, where he reads, "The field is one in which the common law is still in course of development. Courts must therefore act in company and not alone. Analogies in other courts and persuasive precedents, as well as authoritative pronouncements, must be regarded. Even if foreseeability is found, though it is still contested by the respondent that the harm inflicted on Sterling was foreseeable, it is not the only criteria that must be satisfied according to White, as there still remains the omission of Ms. Sterling being in any danger or reasonably believing herself to be in any danger." Lastly, it is submitted that the court must take into account the potential policy considerations concerning for finding for the appellant. In the event that the bench finds for the appellant, hospitals would as a result be far more cautious and unwilling to perform more risky procedures, and would place an unreasonable burden on hospitals and trusts to maintain any prospective psychiatric injury which may occur from any potential claimants. This would bring about the fear of any person who receives a risky procedure to be able to claim for psychiatric harm that they may suffer as a result of the procedure.
What do you say about the dissenting judgment in Paul by Lord Justice Burroughs, when he says, and I paraphrase, that the point that you just made creates a blanket policy, it's draconian and reasonable because it rules out anyone who suffers psychiatric harm from making a claim?
Thank you, Your Ladyship. It is submitted that this dissenting opinion, while it may be correct in fact, even when applied to the facts of the case for Ms. Sterling, that even if foreseeability were to be determined, that the other requirements as set out by the case of White and others would still yet to be met. And as a result, it is submitted on behalf of the respondent that this would not place a draconian limit on any cases brought by any such claimants. If it pleases your ladyships, I will now move on to my third and final submission. It is submitted that the facts of Ms. Sterling's case are more akin to that of a bystander, the test for which is also laid out within the White case, and once again are not met. It is stated within the White case on an excerpt from page 12 of the respondent's bundle, page 460 of the law report, paragraph G, that bystanders are the other classification for which a primary victim may be identified and classified. It is stated, and I quote, "In determining whether a duty exists, the law recognizes two categories of victim. One, the bystander, spectator, or mere spectator, and two, participants, namely those who are directly involved, those who are mediately or immediately involved, and those who are actively involved." This confirms that while bystanders may still satisfy the grounds for being found to be a primary victim as set out by the White case, this further proves that the White case is the correct test to apply in cases of psychiatric harm. To further add to this, if I may direct your ladyship's attention to the case of McFarlane and Caledonia Limited, neutral citation, my apologies, of the second All England report beginning from page 1. This being found on page 108 of the respondent's bundle.
101.
108, my apologies. Would your ladyship care for a summary of the facts of this case?
No, I think we're familiar with this as well. Thank you.
It is submitted that 3 conditions outlined within the McFarlane case for potential claimants to qualify as a primary victim by means of being a bystander are outlined on an excerpt from the judgment of McFarlane and E.E. Caledonia on page 108 of the respondent's bundle, paragraph J. For your ladyship's ease of reference, additionally, on page 10 of the law report, page 117 of the bundle, each condition is separately outlined with additional context to be provided. It is submitted that the third condition is easily not met by the present case and bears very little consideration. However, it is submitted that the next 2 conditions, primarily conditions 1 and 2 of the McFarlane case, bear more examination. As to the first condition, it is outlined that, to quote from the McFarlane case, 117, paragraph A, "First, where he is in the actual area of danger created by the event, but escapes physical injury by chance or good fortune." It is submitted that as Ms. Sterling was under the care of medical professionals, it cannot be reasonably stated that it was only by chance or good fortune that she would have escaped any lasting or long-term injuries as a result of the emergency cesarean.
Presumably the very fact of having a cesarean puts her in danger, does it not?
It is submitted that while it does put her in danger, it does not put her in enough danger to be able to qualify it as a primary victim for the purposes outlined by the White test of being in the zone of danger.
Which is having a general anaesthetic as well, there's risk involved in that too, does that not come into your consideration?
While it does come into consideration, it is, however, submitted that Ms. Sterling awoke, and according to the, presumably off the facts of the case, and my apologies, that there was no injury sustained. And if I may reference back to the Page and Smith case, that even if the foreseeability test is met, according to Page and Smith, that this is only one of the criteria that must be met by the case of White and others. And as a result, with there not being any immediate danger as she is under the care of medical professionals, that hospitals should not be found to be at a maintaining a burden of psychiatric injury. Third and finally, the final condition met by the McFarland case is a situation that may arise. Oh, my apologies. The second condition, my apologies, is where the plaintiff is not actually in danger, but because of the sudden and unexpected nature of the event, he reasonably thinks that he is. It is submitted that Ms. Sterling could not have believed herself to be in any danger, as she was unconscious throughout the entire delivery. Additionally, it was submitted earlier in my submissions that she has not, while she may have been informed by the medical professionals that she was going under a general anesthetic, to assume that as a result of this, she should believe herself to be in physical danger, would find that it would place a very high burden on the hospitals and a hesitancy to administer general anesthetic to put people under, should this arise for psychiatric injury caused as a result of this. In conclusion, it is submitted that the White test was the correct application and correct test to apply in the case of Ms. Sterling, and that she should not qualify as a primary victim as set out by the grounds of her not being in any physical danger, nor perceiving herself to be in physical danger. Unless I can be of any further assistance to this court, this concludes the submissions on behalf of the lead respondent.
Good evening, my ladyships. As previously mentioned by my co-counsel, I am Miss Green, acting as junior counsel for the respondent. I will be addressing the second submission, that June did not witness or witness the immediate aftermath of a sudden shocking event. Therefore, no duty was owed to her by Longfield NHS Trust as a secondary victim. If it pleases your ladyships, I will now begin my first submission. First, as set out in section 2A of the respondent skeleton argument, it is submitted that the negligent act of not reconnecting the equipment monitoring June's baby's heartbeat was medical negligence, not an accident. The negligent care June received throughout her stay at the hospital until she saw her son does not constitute a sudden shocking event, as case law has established that an extended period of events does not equivalent to one sudden shocking event. To support this proposition, I would like to refer your ladyships to page 122 of the bundle, which contains the case of Poole and Another on Royal Wolverhampton NHS Trust, reported in the Supreme Court in 2024.
Could you give me the page number again, please?
That is page 122. This case set the precedent that the claimant must have witnessed or witnessed the immediate aftermath of an accident caused by the defendant to have the grounds for a claim suffering a psychiatric illness.
Ms. Green, can you assist the court with what the definition of an accident is?
If I may refer your ladyships to page 131 of the bundle, paragraph 24.
Sorry, what number again was it?
Page number 131.
Would you slow down as well, please? It is important that we listen to everything, or are able to hear what everything you say.
Yes. The Supreme Court defined an accident as an unexpected and unintended event which causes injury or risk of injury to a victim by violent external means. Following this decision, the Supreme Court held that 3 prior cases of medical negligence should have been dismissed on the basis that no accident was witnessed, as the claimant had witnessed medical negligence, which does not constitute an accident. To ground the proposition that case law has established an accident must have been witnessed to make a claim in psychiatric illness viable, I would like to refer your ladyship's attention to page 154 of the bundle, paragraph 115.
Paragraph 115.
The Supreme Court held, we do not consider that an analogy can be reasonably drawn between the situation where illness is caused by witnessing an accident whom the claimant has a close tie of love and affection, and situations where the claimant does not witness an accident, but suffers illness as a result of witnessing such a person suffering a medical crisis. This clearly demonstrates that the law does not want to recognise that damages for a psychiatric illness can be claimed in circumstances where no accident has occurred, or this will overextend the ambit of negligence with respect to psychiatric illnesses. Applying this case law to the facts at hand, the incident June witnessed of discovering the required equipment was disconnected was medical negligence, not an accident. June received substandard care provided by a medical professional, which constitutes as medical negligence, further evident as Longfield NHS Trust admitted negligence in respect of June's baby's injuries. My learned friends will argue that the sudden shocking event June suffered was over a period of time at her stay at Longfield. However, the Poole case established the precedent that an extended period of events cannot constitute as one sudden shocking event. If I may draw your ladyship's attention to page 145 of the bundle, paragraph 80. The court state the phrases inexorable progression and a seamless tale, which were phrases used in the Walters case, are vague and are not of much help, so the court found it hard to see why the defendant's legal liability should turn on the court's impression of whether or not the facts of the case fit the dramatic pattern of a Greek tragedy. So the Supreme Court overturned the Walters case. This makes it apparent that it cannot be argued that the event that caused June's PTSD commenced upon her arrival at Longfield and continued until she saw her son, because this extended period of events does not suffice to June experiencing a sudden shocking event.
But isn't it sudden and shocking by virtue of the fact that she was unconscious and then wakes up? So it's from the point of unconsciousness to waking up, that's a sudden and shocking event.
It is submitted that when she woke up from being unconscious, she was not aware of her son's injuries. Therefore, she never witnessed the immediate aftermath of this sudden shocking event of her son's brain damage. Does this answer your question?
Great.
Given June did not witness an accident caused by Longfield or suffer a sudden shocking event, Longfield NHS Trust cannot be expected to be held liable for June's psychiatric illness. Otherwise, this will open the floodgate for countless claims and psychiatric illnesses that prior case law has aimed to prevent. If it pleases your ladyships, I will now begin my second submission.
Can we just go back? Yeah,
Of course.
no, that's fine. Keep going.
Okay. Second, as set out in section 2B of the Respondent skeleton argument, it is submitted that June's psychiatric illness was not a consequence of witnessing the negligent act of the equipment being disconnected that monitored her baby's heartbeat, or witnessing the incident of her son's brain injuries being discovered. Therefore, no sudden shocking event had occurred, so her claim is not viable and should be dismissed. I would like to refer your
Can you
lady.
assist Ms. Green? Because I'm just reading the agreed facts, and it simply says that she suffered post-traumatic stress disorder as a result of these events. The facts don't differentiate between the different parts of the events, as I understand them. Is that correct?
That is correct from the facts of the case, but it is submitted as previously established that case law does not constitute an array of events as one sudden shocking event. So by analysing each event that has occurred, it's clear that there was none of these events constitute a sudden shocking event, therefore her appeal should be dismissed. I would like to refer your ladyship's attention to page 190 of the bundle, which contains the case of Taylor and Another and A Novo UK Limited, reported in the Court of Appeal Civil Division in 2013. Would your ladyship's care for a summary of the facts?
Yes, please.
The claimant's mother was injured in an accident at work due to the negligence of an employee causing a stack of boards to tip over on top of her, causing her injuries to her head and her left foot. 3 weeks later, the claimant witnessed her mother dying, so as a result of this, suffered a psychiatric illness. The court held the claimant could not recover damages for a psychiatric illness, as she never witnessed the immediate aftermath of the accident to her mother. The principle was that there must have been a sufficient proximity of the psychiatric illness to the accident causing the death, not the death itself. If I may refer your ladyship's attention to page 205 of the bundle, paragraph F, which contains a quote by Lord Dyson. He states, if the claimant had been in physical proximity to her mother at the time of the accident and had suffered shock and psychiatric illness as a result of seeing the accident and the injuries sustained by her mother, she would have qualified as a secondary victim. Analysing the facts at hand, it is clear June did not suffer a psychiatric illness upon witnessing the hospital staff's negligent act or witnessing, or the immediate aftermath, of the incident of her son suffering brain injuries. Therefore, this negligence and incident cannot be held as the sudden shocking event that caused her psychiatric illness. June developed a psychiatric illness after finding out of her son's injuries, this being a whole day later, so clearly cannot constitute as June witnessing the immediate aftermath of the incident of her son's injuries.
We just pause there. The appellant made the point that at the point of birth, the child and the mother were inseparable, and therefore the mother was a primary victim. The damage occurred at the moment of birth, didn't it? The only reason that the mother didn't obviously see it firsthand at that point was because she was unconscious. But the moment she became unconscious, she was aware that her baby wasn't there, and found out when she was regaining consciousness that her baby was also brain damaged. That is a continuous event, is it not? And that the mother and the child are inseparable. Therefore, the mother is in fact a primary victim.
It is submitted that my learned friend, Mr. Gibbon, has already clarified that she was not a primary victim in this situation due to the fact that it was not reasonably foreseeable of this harm. As stated by Mr. Gibbon, this is not the only test needed to establish Miss June as a primary victim, as established by the White case.
But I'm talking about proximity.
Yes.
Do you take the point that at the point of giving birth, that the mother, claimant, the parent, beg your pardon, was in fact a primary victim at that point?
It is submitted that, as Mr. Gibbon has stated, the baby was not reliant on the mother at this point, and he was a separate being. So when the injuries were sustained and he was separate from his mother, this is when the harm occurred, and the baby therefore was the primary victim and June was the secondary victim. And as June never witnessed this harm or the immediate aftermath of this harm, she cannot classify as a secondary victim. Therefore, this appeal should be dismissed. Due to these facts, June's claim in psychiatric illness should not stand, as she did not witness a sudden shocking event, simultaneously meaning Longfield NHS Trust should not be held liable for her illness. If it pleases your ladyships, I will now begin my third submission. Third, as set out in section 2C of the respondent skeleton argument, it is submitted that June never witnessed or the immediate aftermath of a sudden shocking event. June never witnessed extreme harm to her baby, as she was unconscious during the delivery of her child when it was discovered he had injuries. Therefore, it was not foreseeable June would suffer a psychiatric illness, given she never witnessed a sudden shocking event. This subsequently means Longfield NHS Trust did not owe June a duty of care as a secondary victim. May I refer your ladyships to page 208 of the bundle, which contains the case of Alcock and others and Chief Constable of South Yorkshire Police to support this proposition. This case established the test to determine whether a sudden shocking event occurred, which would mean the defendant owed a duty of care to the claimant. May I refer your ladyships to page 302 of the bundle, paragraph H, which contains a quote by Lord Ackner. He states, "It is reasonably foreseeable that injury by shock can be caused to a plaintiff, not only through the cital hearing of the event, but of its immediate aftermath. However, may I now refer your ladyship's attention to page 322 of the bundle, paragraph A and B, which contain the quote by Lord Jauncey. He states, "The visits were made no earlier than 9 hours after the disaster. So this takes the claimant outside the immediate aftermath of this disaster." Applying this ruling to June's case, June never witnessed extreme harm to her son and never witnessed the immediate aftermath of his injuries, as she saw him a whole day later after he suffered these injuries. This consequently means June did not suffer a sudden shocking event causing her psychiatric illness. May I direct your ladyship's attention to page 298 of the bundle, paragraph B, containing another quote by Lord Ackner. He states, "Whether the hypothetical reasonable man in the position of the defendant would say that the shock-induced psychiatric illness was reasonably foreseeable is a good test to determine whether the psychiatric illness suffered by the claimant was reasonably foreseeable. Analysing the facts at hand, given June never suffered a sudden shocking event, the reasonable person would not say the psychiatric illness was reasonably foreseeable." Applying well-established case law, it is abundantly clear that Longfield NHS Trust did not owe June a duty of care as a secondary victim, so June's claim should be dismissed. My ladyships, to conclude my submission, due to the facts of this case being that June never witnessed a sudden shocking event, so Longfield NHS Trust did not owe June a duty as a secondary victim, we ask this court to uphold the decision of the Court of First Instance and to dismiss June's appeal. In my respectful submission, what we should not be doing today is providing a legal precedent to uphold claims where no sudden shocking event occurred. Otherwise, this leaves persons and businesses in a vulnerable position to be held liable for a psychiatric illness they never caused. Unless I may be of further assistance, this concludes the respondent's submission. Thank you.
The appellant is to exercise the right to rebuttal. Yes. You'll have 5 minutes outside to confer and include necessary.
Seems like the hot desk. Legal education. So I have 1 year somewhere, it's like.
Found that.
The appellants would like to address a couple of points made by the respondent. Firstly, the argument that there would open a floodgate of litigation claims regarding psychiatric harm. When we're regarding the concern about potential floodgates, it's essential to still prioritize the well-being of patients like Ms. Sterling who have suffered genuine harm. PTSD is a recognized psychiatric harm, and measures can still be implemented to mitigate the risk of frivolous claims, such as requiring expert testimony and medical evidence. Additionally, healthcare providers can still take proactive steps to improve patient safety and minimize the likelihood of medical negligence. When Ms. Sterling checked into the hospital, she didn't have any pre-existing situation, and the negligence caused by the hospital was one of the main factors that resulted in her PTSD. Regarding the point made by the junior respondent in case the harm of the baby occurred at the time of the cesarean, the facts of the case discuss that the harm of the baby was caused due to the delay, which was the negligence of the hospital. The brain damage didn't occur during the cesarean section, and the only reason Ms. Sterling had a cesarean section was because of the hospital's negligence. And finally, the junior respondent's assertion that the court must not set a precedent for psychiatric claims with no sudden shocking event does not acknowledge the precedent set from the Paul case. And the judgment states that the law had taken an unfortunate wrong turn when adding the requirement of a sudden shocking event, which the Supreme Court has corrected.
What do you say to Mr. Given's submission that the authorities you relied upon and the High Court authorities are only persuasive in your arguments to this court?
When considering the High Court's decisions, I wasn't referring to the judgment made by the High Court, but in the YAH case, the court employed the principle of fetal maternal interdependence, which was the main point of my submission. That concludes the rebuttal on behalf of the appellants. Thank you. All rise.
Oh, no. Yes.
No, sorry, thanks. Can you drink it? Probably.
It's usually from.
It was just orange juice, right?
Yeah, it's orange juice.
Orange juice. All rise.
Thank you, everyone. We were extremely impressed by all of you. The standard is astonishingly high and you should be very, very proud of what you've achieved. We were blown away simply by the fact that you are first years. To have produced a moot of that calibre at this early stage in your legal career is quite honestly gobsmacking. So very, very well done. The decision that we've come to is that the respondents would be the winners of the moot. Unfortunately, the appellants, you were always going to be on the back foot, not least because of the recent decision in Paul. And the decision that we made was based on Paul. But that does not detract from what you have achieved. Considering that you have the odds firmly stacked against you, your both of your performances were outstanding. So thank you. There is only 2 winners, and the winners are in no particular order, Tanvi and Sean. And I understand that there's a cash prize and a mini pupillage at Westgate Chambers, so welcome to you both. And a period of work experience with Mayo in Baxter to the runners-up. Yeah.
To the winners.
To the winners. Well, excellent.
There's also cash as well for the runners up, isn't there?
Yes.
Yeah.
Get the cash.
And there's a trophy, there's like a massive sheet as well, but he's willing to get his names on as well.
Yes. So well done.
Thank you.
Good job.